Hello, everyone. My name is Alexandre Pacheco da Silva, and this is a Law and Technology series, a set of interviews with incredible scholars to discuss the impacts of new technologies in the legal field. I am a law professor at São Paulo Law School at Getúlio Vargas Foundation and one of the coordinators of the Center for Education and Research and Innovation. Today, we have Professor Lyria Bennett Moses. She's a director of the Aliens Hub for Technology, Law and Innovation, and a professor in the Faculty of Law and Justice at the University of New South Wales, Sydney, Australia. She is also a co-lead of the Law and Policy team in the Cybersecurity Cooperative Research Center, and Professor Lyria Bennett Moses explore the relationship between law and technology, and that's why we invited her to be a part of this initiative. In 2020, I had the opportunity to visit the Aliens Hub at the University of New South Wales and exchange ideas with Professor Moses that from now on, I will call Lyria, if Lyria, you allow me to do it so. So we divided this interview in 3 questions, Lyria. And the first one, it would be, how is technology impacting the legal field? And if I may add here in this question, how do you see this field growing, or this question growing in the legal field?
Okay, so I think it's important in considering that question to look at 2 dimensions of it. In other words, there's 2 different ways in which technology impacts the legal field. The first is technology being used in legal institutions, like in courts, or in the legal services industry, right, in law firms or and so forth. And some of that is familiar across all organizations, right? So everyone uses computers, everyone has internet access, everyone uses video conferencing now, right? So there's a set of technologies that, you could ask about the legal field, the banking field, and it will look very similar. And then there's other applications that might use familiar methods, so machine learning or different kinds of software, but that have a more bespoke application in the legal field. So here we can think about things like machine learning in due diligence or in discovery, or we can think about some of the tools that have been created for negotiation, sort of online, interactive, process-driven tools. Or we can look at things like predictive analytics in litigation, right? So you can predict the probability of success or the amount of damages and then make decisions about settlement or litigation strategy around that. So, they're really legal tools, although they're built off, obviously very familiar kinds of platforms and tools. But that's still only one dimension. The other dimension is, if you like, when law is called on to respond to technology. So we hear, oh, we need to regulate artificial intelligence, right, as an example. Or we need new legal frameworks to enhance cybersecurity, or whatever it might be. And in this space, it's not so much about lawyers using technology, but the law in a sort of more abstract sort of legal frameworks, regulatory frameworks type vision, being called on to do something about technology. And this is obviously kind of my favorite part of it, because this is where I began my scholarship. And in this area, what you see is a pretense of newness, but actually often not. So you can go back and you can find things like hare and tortoise metaphors, right? Oh, the hare of technology is leaping ahead of the tortoise of law. And you're seeing it now about AI or about whatever it is, but you can go back and you can see exactly the same language about some of the really early developments in medicine, when medicine starts to technologize and so forth. So there's a sort of newness of the particular technology we're talking about, but you can trace it back from the ones we're talking about today, like AI, through to the ones we were maybe talking about a few years ago, like nanotechnology, through to the ones we were talking about a few years before that, like genetic testing, through to the ones we were talking about a few years before that, like computers. and you can keep going back, you know, in my own work all the way to, you know, railroads and barbed wire fences and, you know, really old technologies, but nevertheless that have this same idea of law not keeping up. Now, the metaphor is, of course, silly, because if you know the fable of the hare and the tortoise, I don't know if the same fable is told in Brazil, the tortoise won the race, right? So, you know, it's kind of meaningless, but the image is there. And the sort of silliness of the metaphor, this idea that law and technology are in some kind of race, hides an important truth. And the truth is that law creates rules that make sense or that operate well or are meant to operate in a particular state of the world, right? So we have road rules for cars that drive on wheels, not for cars from Back to the Future that fly, right? Because we don't have cars that fly, so we don't make road rules for them. So the rules operate in a particular context, but of course, while we don't have flying cars yet, technologies keep changing and changing that world we're living in, so that the law is always kind of set as well as it can be. I mean, it's never perfect. Law is not a task of perfection, but it is always set for, you know, a slightly historical landscape, if you like. So in that sense, how is technology impacting the legal field? I think those two conversations, they do overlap a little bit, because you can talk about things like regulating bots and giving legal advice or something like that. But mostly, I think you need to sort of think about them distinctly. And in both cases, it's really important to have historical perspective, to not pretend this is new. This just happened when AI was invented. Because, you know, I go back, my you know, father, you know, is sort of now mostly retired, but, you know, he was a sort of practicing lawyer for a very long time. You know, he would talk about the radicalness of when you no longer needed to use carbon paper, right? So you know, it's not, the particular technologies will always be new, but the stories of change, the stories of disruption, and what we as a legal profession do about it are in fact very old. So new, but also in cycles of sameness.
Perfect. One thing that could give some context regarding my second question that I would like to present to you, Lyria, it is the idea that there is a field for research and discussions that we can call law and technology, because usually, and we can go back for papers as, for example, the classical one regarding the discussions between just Easterbrook and Lawrence Lessig regarding the idea of law and technology field, or law of the horse, something like that. And usually scholars here in Brazil, especially the traditional ones, would say that, oh, technology could be an object for the legal studies, for law, for legal scholars, but we do not have a field that we can call law and technology. We need to prepare our researchers to study the law, to understand the meaning of the law, and technology could be one of the subjects that they needed to deal with, but there isn't a field that we can call law and technology, or at least we can call it a course that would be like an optional course for the students in their latest years, but we do not have a revolution regarding that. So in your view, is there a field of study that we can call law and technology?
Okay, my answer to that is going to be yes, but at the same time, both Lawrence Lessig and Justice Easterbrook were both right. So let me break that down a little bit. First of all, I should start out when I was a very baby academic during my doctorate, which I did in the United States. My doctorate was on the impact of technological change on law. And so I can't really now say there's no field of law and technology, because my entire thesis was to work out what that might look like. So what I was trying to do, and this is, you know, a long time ago now, it's in the field, it's almost sort of ancient history. But what I was trying to do was to say, okay, there is a commonality here. So if you're going to have law and technology, you have to answer it on two fronts, right? On the one hand, you have to say there is something to talk about here. There is something interesting that you don't just get from contract law, property law, each in isolation. In other words, there is a common story that we can and should tell. And then at the same time, you've also got to say, and that story is technology as a category and not something smaller or bigger, right? So what do I mean by that? So, I mean, there's a lot of different definitions of technology, and obviously when you're writing a doctorate, the first big task is a definition, and I came up with one I liked, which essentially focuses on technology as capability, right? Things that you can do that you couldn't do before. And that made sense to me as a legal scholar, because the law says what you can and can't do. I mean, it says a lot of other things, but at a very fundamental level. So if you can do new things, suddenly it's like, well, should that be permitted? Should that be regulated? Should that be prohibited? So that made sense to me as a definition that we could talk about within law. So what is it about that as a category that is special? And what I did in my thesis is I actually went back and I looked at, as I said before, everything, right? Barbed wire fences, railroads, computers, genetic testing, nano. We didn't have the sort of magic AI word yet, but really it was sort of other words that sort of, you know, became AI later. But we could look at all of these things and say, is there something here? Is there any reason for someone who's trying to work out how the law should apply to a new computer system or whatever it is, to go back and look what the health lawyers were writing about IVF, right? And some of the legal issues that arose there. Is there something that these can learn from each other that you can't get without taking it at that broad level of technology? In other words, is there something across technologies, right? So in other words, some pattern that applies, whether it's medical or information, some that applies across doctrinal categories. So we couldn't just answer these questions by focusing on contract law or tort law or anything else. And that applies across history. So it's not just a moment. It's not just something that's happening now. Everyone always thinks it's happening now, but it's not. It's something that we can actually go all the way back. And that was what my thesis was about. And I actually pulled out themes that, you know, raised issues for the law coping with technological change, where you could come up with this systematic way of thinking about it that did apply across technologies, across doctrinal categories, and across history. So that was my big thesis task. And as I said, you know, baby junior academic starting out in the world, but that's what I wanted to create, because I wanted to see, is there a field of law and technology? And I came to the answer, yes, because there were conversations that could happen on that dimension. The next challenge, of course, was actually getting a job, right? So I was going, and I wanted to move back to Australia. So, you know, I was applying for jobs in Australia rather than in the US. And there was no way you could go into a job interview at the time in Australia and say, I am studying law and technology, and that is the field I wish to research and teach in. I had to say, I've got some kind of eclectic scholarship over here. Don't worry, you know, this is the kind of thing I'm trying to do. There's a few interesting questions, but I'm happy to teach property law, right? Or I'm happy to teach equity, or I'm happy to teach certain subjects that are those core standard legal subjects. And that's how I got my job. And you know, for years, you know, I did teach, you know, property law, equity, and so forth, because you had to be in one of those categories to even be an academic, right? You couldn't just say, oh, I do this fun stuff. I call it fun stuff. I think it's more fun. But you couldn't, you know, that was fun to sort of play with. And, you know, certainly no one really cared. You know, you could do research really in whatever you wanted, but teaching wise, forget it. There were no subjects, and no one was interested in, you know, really me creating any at that time. So now we move to the modern world. Names of, you know, there's a million conferences that throw the word technology in, or not technology, then, you know, AI, blockchain, you know, pick your favorite buzzword. Journals. I see job ads now, you know, all of which I could have applied for when I was a junior academic. You know, we want someone to do technology law. I am director, as you said, of the Allen's Hub for Technology Law and Innovation, and that isn't the only such centre or sort of area focusing on this. We've got, in our faculty, we have really strong membership. We have lots of academics who are otherwise lawyers in very traditional areas, but are part of the hub because they want to study whatever it is, some particular technology and how that intersects with research they might otherwise be doing on whatever that might be, fiduciary obligations, whatever it is. They want to sort of understand the relationship between those things. So they become members of the hub and join that. And across the university, across lots of universities, this is now a thing. It was not a thing previously. It's also where people like to give their speeches, right? So there's sort of great speeches now. I mean, not all speeches, obviously, there's a lot of topics, but there are lots of speeches from deans, from, you know, university leaders saying, you know, the future of, and of course, law and technology is often part of those stories. So there's two answers, right? Is there a field of study we can call law and technology? I always thought there should be. I think now it's real in the sense of, you know, what creates a field. There's lots of academics publishing in journals with that title, other centers with that title. And, you know, even if is actually somewhere in between. There is a lot of hype. There's a lot of people thinking, let's do this because it's trendy. Let's do this because AI and take over everything, and there's only going to be machines in the future and whatever. And I think when that happens, what I'd say is often what you get is a focus on the technical, when the real problem isn't actually the technical, right? When we're staring at the machine and not thinking more broadly. And you can see this, I'll go back to AI, in the way we talk differently about AI and good old-fashioned statistics. So if we're worried about data-driven discrimination, if we're worried about looking at data and finding trends in historic data and using that to predict the future, and then using that to make decisions about people, you don't need AI, you don't need the machine, you don't need systems. Good old-fashioned statistics has been doing that for a very long time. You know, more and less sophisticated techniques, sometimes just counting type techniques, not even fancy statistics. And we have, you know, if you look at what's been done historically in prison systems, for example, in terms of deciding who goes to the high security, this is not new. A lot of jurisdictions have used data in those in simplified models or whatever it is, but they have used data to make those kinds of decisions. And as a result, have discriminated against certain groups of the population because of, you know, correlations with other data points they're looking at, even if they're not looking at it explicitly. Exactly the same thing going on now with AI. So where do I want to come to in that? I think there's a field of law and technology, but I think the field itself has to maintain its own skepticism and not focus on the technology. So I think a good field of law and technology, first of all, includes deep grounding in the legal basics. In other words, you know, you can't do law and technology unless you're happy to travel across contract law, property law, you know, a whole range, criminal law, a whole range of fields, right? And understand those and not make stuff up. You can't do it without also understanding the technologies to some extent. I mean, I always say I can't program in R, right? I can't write a machine learning algorithm, but I have read a textbook on machine learning. And I think that matters because I actually understand what it is doing. And that's why I keep talking about statistics, because at the end of the day, you know, it's driven by a lot of similar methods and different methods. I'm not saying they're all the same, but you know, at the end of the day, the problems of statistics resonate in the problems of AI. It's not a new problem necessarily. So you need to understand the law, you need to understand the technology, but then you also, I would argue, need to take Easterbrook's point that it's not that we can just look at the technology, right? It's not that we want to construct a whole law of AI, that would somehow be a useful exercise. What we want to do instead is say, okay, there's this new thing, AI, new, not new, let's gauge that it's a complicated history, but there's certainly new techniques that are out there and new techniques being deployed. This changes the landscape. This changes capabilities, going back to the definition I picked for my thesis. It changes what people can do, right? And what kinds of things employers can do, for example, in hiring people and so forth, et cetera. Are the laws we have at the moment around, for example, non-discrimination, or around, for example, reasons for decisions in administrative law, whatever area we're looking at. Are the rules operating effectively in this new context? And if not, let's not just go, oh, let's have a special law of AI. Let's go back and think, what is the best solution? And maybe the solution actually goes back to thinking like Easterbrook did, not about the technology, but going back to say, let's look at the discrimination law. Why isn't it working? Well, what assumptions were built into that law? How can we write it better? And if we can do that, right, then I think not only do we have a field of law and technology, which I think is just a reality now, but we have a field of technology that I think much better responds to the kinds of concerns raised by Easterbrook, or the kinds of concerns that a lot of traditional law scholars have of this is just some hyped up, crazy, trendy focus, but actually get the legal settings right for the world as it evolves.
Excellent. And just one thing to share with you, I started my career teaching intellectual property as you did with property law. So it was a possibility to start regarding when and how can we do the fun stuff. And I think the fun stuff, it's the precise definition to what the field of law and technology is. But finally, Lyria, my third question is, what should a law school do regarding the impacts of technology in the legal field? And I'm asking you this because usually we have a lot of discussions regarding, at first, the idea that we need to engage a lot of professors from traditional areas, for example, property law, criminal law, so on and so forth, with this subject. And they will usually say that, oh, it's difficult for me because I don't know anything about technology, so it would be very difficult to do it so. And we need to engage the students and the young professors to think and include in their agendas topics regarding technology. So in your opinion, what would be a good strategy for a law school regarding that subject?
Okay, so I actually have written a book chapter on this, although it's an Australian book, so it wouldn't probably be available in Brazil, but I'm happy to give anyone the link to that who's interested. There are, I would say, 3 different things that law schools need to do, and I'm going to put them on different dimensions. The first question is, what do all law students need to know about technology? So we have, in all law schools, there are fundamental things that we call the core curriculum, right? Where we say everyone, you can't finish law school without knowing how to create a contract, right? It doesn't matter if you want to be a criminal lawyer, everyone has to know that, right? And everyone has to know, right, the basics of, what criminal law is and how it works. And so we have these sort of fundamentals. And there are also fundamental things that I would argue all law students need to know from the field of law and technology. One is, where the technology directly affects an area of law in a way that they need to understand and have answers to and not be surprised when they go into practice. So, for example, just as we say that all law students need to know what a contract is, I would say as part of learning that, in fact, as part of contract law, they should also learn, does a smart contract always fit that definition? Right? In other words, they need to understand that. And it's not that they're learning some foreign thing or some foreign subject. They have to understand what a contract is. So we can show them, okay, here's a smart contract. So this is what someone's calling a smart contract over here. Is that a contract? And if so, why? Traditional doctrinal methods to get to the answer to that question. Similarly, if we look at things like automated decision-making in government, right? And we have traditional administrative law. And administrative law says you have to give reasons for decisions, certain kinds of decisions, and certain kinds of decisions can be appealed through judicial review, et cetera, et cetera. I'm not an administrative lawyer, so, but broadly, I know that much, I think. And again, we need to have all students understand, can, for example, reasons generated by a computer system be reasons for decision? And if so, what features do they need to have? What properties might they need to fit what we already know the law requires? And again, this should be able to be taught by administrative lawyers because they should know what are the requirements for reasons? What are the requirements for for decisions, right? And whether these kinds of systems can meet it or not is simply applying the law they should know really well to a set of facts that, you know, aren't that technically complicated, actually. So we need students to do that. In other words, what we don't want them to do is learn the law for the world of, you know, the 19th century or something, and only know cases about horses. And you know, we need them to be able to understand how the legal principles they're learning apply to the world in which they're going to be operating. And that should be everyone's job. So we don't need law and technology as a subject, but we do need every subject to make sure that they're teaching students how to apply the principles they're learning for the world they will enter. So that's an all law students thing. Another all law students thing is that all law students should have a curiosity and willingness to learn and understand what is relevant that comes up as they practice. You know, I've always thought of law as an area where, you know, you need to kind of be able to learn everything, right? If you're working, you know, for a client in a particular industry, you need to know something about that industry and how it works and what your client's objectives are, right? If you're applying, you know, the law to a particular scenario and the scenario involves some kind of technology, which increasingly more and more real world scenarios do, then you need to know enough, be able to learn about it enough to answer your client's question. So we can't teach them everything because we don't know what fields they're going to go into, but we need to teach them that they shouldn't be scared of it and how to be curious and learn. And often they will have experts either in their client organization or in litigation, there'll be experts that are witnesses, and so that they can learn from people. They don't need to be the expert on everything, but they need to be able to do that well. The third one is technologies in legal practice, right? Again, I don't think law schools need to teach students the how-to of everything because they learn a lot of that on the job, but they need to be understand enough about technology to be wary of over-reliance, right? And this gets harder as the technologies get more opaque. But, you know, you want students to be able to use things like machine learning in due diligence because it can make the process more efficient. But they also need to understand that it's not magic fairy dust. It will tend to make certain kinds of errors in certain kinds of scenarios, and they'll need to be aware of the kinds of systemic errors that can occur so they can do due diligence better, right? So we need to sort of give them that. And that's, again, all of those things, all law students. The next question is what some law students should have the opportunity to learn, right? So this is now less about what's in the core and more about what kinds of electives should law schools be offering to students. So those interested in law and technology as a field of practice, as a field of study, either way, can get some courses in that area. And, you know, different universities offer different courses, nothing's prescriptive. I can tell you the ones that we're offering and why I think they're good. So we have a course called Designing Technology Solutions for Access to Justice. This is teaching law students, they work in project teams and build legal tools for not-for-profit organizations. So they run a small technology project. It's not fancy tech. They're not building complex machine learning things. It's really just a very basic kind of process tech. They don't need to learn how to code, but they can build a tool that can answer a basic legal question or filter a matter to the right person in an organization or whatever it is. And they work with the client in teams. They learn project management. They learn time management. They learn working in a team. They learn working for a client. They learn pitching and presenting. They learn, you know, creative thinking, design thinking. So they get a lot of skills that even if they don't go on to become legal tech folk, I think are generally useful, you know, whatever they go on to do. You know, the breadth skills, if you think about, you know, if you heard of the T-shaped lawyer, there's the deep skills like knowing contract law really well. And then there's the top level, right? How do you work effectively? And that's the kind of thing. But they're learning legal tech and the limits of legal tech. They learn it's not magic fairy dust, that it almost always has bugs, that someone who does enough case studies can always find a route that doesn't quite get to a sensible answer, right? And that's important for them to understand too. Another course I teach, and this one's with the University of Zurich, when we can travel. It hasn't run for a couple of years, which is law and technology, and it takes a sort of comparative perspective. And this is a sort of classic law and tech subject. It does the kind of things I was talking about. You know, how does law respond to technology? What are some of the case studies, you know, to understand this pattern and so forth. There's another, that sort of, you know, that's fun because the students get to travel to Zurich and learn to ski as much as it is because of the subject matter. Although, like I said, it hasn't run recently. Regulation for cybersecurity is another course that I've just started. And this one is totally cool. This is kind of my favorite, maybe because it's the newest. But I teach this with engineering. So students in engineering do a course called Security Engineering and Cybersecurity. And students in law do regulation for cybersecurity. And they do problem solving and tutorials together around, you know, what should an organization do? Or what should the government do, right, in response to this particular risk or threat, right? So they work on these kinds of things collectively from a technical and legal governance perspective. We run sort of law classes for the law students, which teaches them the legal issues in cybersecurity around what legal frameworks exist and how they apply. The engineering students also do their separate classes where they learn, you know, how to do encryption. I mean, not at a detailed level, but, you know, what encryption is and how to measure encryption quality and how protective different kinds of encryption are and so forth, you know, from a very technical perspective. But the students come together to learn about how do you assess risk? How, you know, what kinds of cyber problems arise in the world? Is cyber just a technical problem or is it much bigger than that? And so forth, et cetera. You know, how do you understand threats? How do you understand security? How do you think like a security engineer, right? How do you think for security and what's, you know, what's needed for security? So they come together for those classes. And as I said, the tutors are all problem-based around scenarios where you're advising government or you're advising a corporation or whatever on a response to a situation. That course I think is really good because it gets people used to relying on each other's expertise, right? That the law students can go to the engineers and don't have to have the technical answers, but need to be able to work with people who can generate those answers. And the engineers learn how to talk to people who are coming at the issue from the perspective of regulation and governance. And you know, it's not, they learn to work together in a really positive way towards common solutions. And I think cybersecurity is a really important area for lawyers because not only is it a very rapidly emerging policy area, I mean, in Australia now we have, you know, 5 new bills a year almost that touch on the issue of cybersecurity or are trying to do something about cybersecurity. So not only is it a rapidly moving area legally, but it is, you know, increasingly important, you know, from an organizational perspective, and an increasing threat. And part of the problem, I think, is that people don't talk to and understand each other, right? And that means that the technical people are trying to solve a technical problem, the legal people are trying to solve a problem they don't really understand, and we're not getting anywhere. So this is like, you know, fixing the world through teaching, and getting the right next generation for that problem. And then we have another course that I don't even teach because it's not my area on sort of fintech and regtech. So we have these kinds of courses, right, is the point. And I think universities should be thinking about what opportunities do we give law students so that they can be the future of policymaking, so they can be the future of legal practice, so they can be, you know, they can position themselves to you know, solve the problems of the future. Sorry, that's my mum calling on my phone in the background. Okay. Finally, another thing I think law schools should do, and this is a bit of an Australian pitch because I know it's different everywhere, I actually don't know what Brazil does, is what law students should be able to do outside of the law. So what other courses, not that we couldn't even teach if we tried, should law students be able to access? Now in Australia, we have a system for this because we have dual degrees. So everyone who's doing undergraduate law is doing another degree program at the same time. Does Brazil have that?
No, we have just a graduation in law with the possibility to take other courses regarding, for example, business and other courses within your university, but you will only take your graduation course.
Okay, so I'll talk about this in the Australian context, and maybe in Brazil it would just have to be about access to courses. So one of the things I did is actually create a new dual degree program. So we have dual degree programs. You can do arts law, commerce law, science law. We also have like computer science law that already existed. But I actually, working with the Faculty of Science, linked law to data science and decisions. So data science and decisions is already a 3-faculty degree. So already they're doing mathematics, computer science, and business to understand data science, but also to understand practical applications of data science. So how you use this kinds of techniques for important decisions within organizations, within business, right? So that is already a 3-faculty program. And we created data science and decisions / law, which means as well as doing all of that, they get a law degree. And that to me, it's not going to have huge numbers of students, right? It's a long program to get through all of that. But having some people who can do both, not just a tourist, not just I did a course, but can really be expert in all of that, they are the people who will be, making the decisions about, from a law firm, how do we use these systems? What can we get out of it? What are the limitations of it? From courts, what can we do? But what would also be inappropriate? Where would we lose the rule of law, right? If we started over automating, and they're the people who understand both sufficiently deeply. And you don't need millions of them, but you do need some of them, and I think they have a great future to take on those kinds of leadership roles at that intersection. You can also do, people in Australia also do like masters, right? So, you can do a law degree and then do like a master in cybersecurity and so forth. So there are other routes. And again, those will be different in Brazil, potentially, to what they might be in Australia. But I do think that there are, not all, but we should have people who are experts in law and experts in particular technologies. And I gave the example of data science. I also think we should have people who are expert in cybersecurity and expert in law. I think we should have people who are expert in some of the sort of medical technologies and expert in law, right? Again, not many. We don't need thousands, right? We don't need to say this should be as common as, commerce law and arts law and all the sort of common duals that Australian students do. But we do need some, and the universities should be prepared to run dual degrees that give people important intersecting expertise. So that's it. That's what I think law schools need to do. So it's quite a busy agenda, but yeah, and I'm happy to share the link to the book chapter too.
Wonderful. It's a large agenda with several topics. I was thinking about the possibilities that we can do and implement here in São Paulo. But for this interview, I think we are at the ending of the interview, and I thank you again, Lyria, for accepting our invitation and to be a part of this project. This project would be very important to us and other institutions here in Brazil and in Latin America. So thank you again to be a part of it.
Thank you for inviting me, and good luck with the grand projects.
Thank you. And for those that are watching us, see you next time. Thank you very much.